How's it going today so far? You guys, is it last session? You guys get good info? Hopefully, our goal is for you guys to be able to walk away. One of the things I really like, folks in the accounting, all these numbers people, they'll got their cameras out taking pictures of the slideshow. So that means that good content. So I'm glad to hear that. Glad to see that, I should say. This is, with regard to the employment laws, this is, I think, one of the most significant areas affecting the church today. In terms of the risks associated with the church, with lawsuits, just compliance. The church is generally, and when I say the church, I'm speaking really more of ministries at large, okay? New laws that have come down in the last year and a half have been so significant that we're going to need to dive into in depth into some of them. Okay, so we're going to talk about first. I'm going to try to spend maybe 20 minutes here, and then I'm going to ask Mike and Anna, Mike,
I'm back.
Anna,
I'm back up.
to come up and talk about some of the details that I don't necessarily get into the weeds on with regard to employment issues. Now, we're going to talk about first misclassification of employees, wrongful termination and ministerial exception lawsuits potentially brought by employees, job descriptions, employee handbooks. Start off with Dynamex. Dynamex is a case that came down in 2018. Dynamex upset the apple cart in the employment world for everybody. Now, what Dynamex says, now how many of you guys have heard about Dynamex? Any hands? Okay. All right. Some of you have heard, others haven't. If you're our client already, you've probably heard about it, I hope. I know Centerpoint. Anyways, looking here to see. Okay, well, good. So now you know about it. But here's what Dynamex is all about. Dynamex, when it came out, it said, a lot of times here in California, and actually all across the country, we have people that, it doesn't make a lot of sense to put them through payroll and, have to sign a W-2 and do it. They come and they serve once a week. They're our worship leader. So we're going to give them a gift of $500 a month to be our worship leader. Maybe you've got some retired guy or gal who comes in and says, I just like trimming trees and, coming in, sweeping and doing things like that. You don't need to pay me. And no, we really should pay you. No, you really don't need to pay me. Look, well, how about if we give you $400 a month? And okay, that's really nice of you. Thanks. And so now you have an independent contractor. You got an independent contractor worship leader. You've got counselors who say, you know what, this is professionally, I'm employed by this counseling service over here, or I work for a hospital, and I'm a counselor, and I want to give my services to you as a church, and I want to be able to come in and from a spiritual side, be able to help counsel, and I'll come in once a week, evenings, 5 to 8, 5 to 9 every week. You guys can schedule appointments for me. How many of you have anything like that? Anybody? Okay. Can't forget I just brought all that up. But it's true. It happens a lot, actually. By the way, I feel very self-conscious right now because I took my ring off and I forgot to put it on this morning. And I'm in front of a bunch of church people. I don't normally, if you look closely, there's a little tan line. So I really am married, and I feel very self-conscious.
You want to borrow mine, Bob?
I do. I honestly do. It's on. I lost my ring the other day. Well, not the other day. Like a month ago. I was with my kids. We went to Mammoth, and I lost my ring, and I knew I put it somewhere. I found it 2 days ago, and I was wearing an old ring for the last 3 weeks, so I'm really self-conscious about not having it. I found it in my shoe, which is where I put it, because I had to put it in a safe place when we were skiing with my two boys, and we're changing it in the car and put it in the shoe. And anyways, I found it yesterday morning, my wife said, I found my ring. Said, where is it? It was in my shoe, of course. And she said, what's in your shoe for, stupid? So she wonders how I function. But there's some things I know, so I think you can talk. I only know a little bit, and this is what I know here. So we'll talk about these things. So you have counselors that are working for you. And really, they are, periodic. They come in, but they're consistent. So then the big question is, now that Dynamics came along, Dynamics comes along and says, it establishes this new test for independent contractor versus employees. And it basically says, everybody is presumed an employee in California if they are being paid to do a service, unless they fall under an exemption. The exemption is this 3-part test. And there's just a huge heavy burden put upon the employer. Mike, I'll let you address the 3-part test briefly, or did I? I don't think I put it. Oh no, I did. I'll address it. I'll address it so we can get through nice and quick. So there's a heavy burden on employers. Makes it real difficult for employers to show it's an independent contractor. And so one of the big things out there with lawsuits coming by these class action lawyers is they're bringing lawsuits for class action for wage and hour claims. Basically saying, you know what? They treated me as an independent contractor for the last 5-10 years, but I wasn't an independent contractor. Based upon this new test, I really was an employee. And this new test, by the way, is retroactive. It applies retroactively. So what happens is, if they claim I should have been entitled to my meal breaks, I should have been entitled to overtime, I should have been entitled to all these things, vacation time like all these other folks, all of the benefits you get as an employee, I should have been entitled to all that, and I didn't get it. So these lawsuits are coming now. And it's a real big deal. And so this case upset the apple cart in California. How does it apply to you? Well, do any of you have independent contractors that you guys have paid as independent contractors? Raise your hand. And I say you guys, meaning churches. Okay.
Yeah.
What type of person is this?
Guest speakers. We do put, we'll do what we call an honorarium. If it goes over a certain amount, then they get it.
Okay.
I'm drawing a blank on the
That's fine.
form.
But guest speakers, anybody else?
Could be an actual contractor doing work, and they give a bid.
Okay.
And we pay them.
All right. Anybody else with independent contractors?
Choir members, singers, choir.
Singers.
I'm near Chapman University, sometimes I'll hire them.
Okay. So they come and they sing during a worship service, a special service? Are any regulars?
Correct. Oh, yeah.
You have regulars? Okay.
Guest musicians,
Yeah, just guests, do they come just periodically or on a regular basis?
once in a while. Not regular.
Okay,
We have regular musicians, but
okay.
once in a while, they'll take vacation. Shame on them. And we'll have to have somebody play in their absence.
Okay, next.
Christian counseling service organization, therapists, and from 5 hours a week all the way to 20 hours a week, and they may have several work.
Is that what Agnes did?
No, it's Christian's AACCS.
Okay. Oh, of course, it's, yeah.
Right.
Sorry, we did this big merger for them.
Yeah,
Shoot me in the head.
yeah, we can sell it.
Okay,
We had a guy who did salons and janitorial and any handyman stuff around, and he was an independent contractor. He's just now recently, we've made him an employee,
okay.
so.
We have an accountant that's an independent contractor.
Do they work in your office? Come to your office?
And they work remotely too. They have their own accounting business.
Okay,
IT.
IT. Anybody else? Okay, are any of you independent contractors here? Okay, good. Oh, you are? Okay, you should leave the room because I don't want you to hear. The church, not you. Disclaimer.
Yeah.
All right, okay, but here's the deal. You think about all those people we just talked about. So they are an independent contractor unless they satisfy all three of this test, A, B, and C. The worker is free from the control and direction of the hiring entity, the church, in connection with the performance of the work, both under the contract for performance of the work and in fact. A lot of people say, okay, I'm going to get around this because we're smart. We're going to put in our contract that we don't control you whatsoever. But off the paper, you got to show up to church because you're the worship leader. You have to be there at 6:30 in the morning to practice and be prepared and organized and all these. Okay, it's one thing to put it on paper, it's another thing to, what's it really mean? How's it really work out? Next thing has to be satisfied. The worker performs work that is outside the usual course of the hiring entity's business. Church, outside the scope of your normal business. Okay. Third, the worker is customarily engaged in an independently established trade, occupation, or business. Independently established trade, occupation, or business of the same nature as the work performed. Okay. Go back to the beginning. We have guest speakers that you pay periodically that come in. Do they satisfy this test? I think so.
Yeah.
I think they satisfy the test. They come at your request, you're paying them, they have their own independent work that they do. They're not employees of you, you don't control, you might talk to them about when they're supposed to come and when they're supposed to speak, but that's pretty clearly outside the scope. Choir members. Ooh. Choir members. So, free from the control and direction of the church. Are they free from your control in the performance of their singing at church? Whether, in actuality and pursuant to any agreement you have. Are they free from your control? In other words, do they sing the songs that you require them to sing?
They're singing the ones I tell them to sing.
Probably.
They're not singing something different than the rest of us.
And they have singing unison together.
That's right.
The worker performs work that is outside the usual course and scope of the hiring entity's business. That's tough for you to satisfy because you have a choir in your church. And this is part of your worship. It's part of the ministry. Worship leader, choir members, people who come and provide music, that's part of what you do. It's part of your business as a church. It is what you do. It's hard to get away from that for those types of individuals. And are your choir singers, are the choir members engaged in a practice where they actually get paid to sing all over the place at different places?
Yeah.
Some yes.
Some yes.
Some yes, yeah.
Okay, so that might satisfy that. And so for some of you who hire periodically, you're late.
I can teach you the whole thing. I paid attention last year.
I was taken after him. He was telling me that's what he does
We
when
just got rid of our last
Tell
one.
people come.
Got rid of it, moved over to a, we're good.
All right, so
Is this all of the above must be satisfied or any of the above?
all of the above must be satisfied in order for them to be deemed an independent contractor.
Okay,
So you hire someone to come in and do worship periodically, once a month, once every 2 months. They fill in, like at one of the churches I attend, there's a guy that comes. He's probably once every 4 or 6 weeks, couple months, 3 months go by, he's back. Well, he performs work that's outside the usual course and scope of the business. No, that he's doing something that is part of the function of the church. So fails that.
Yeah, B to me seems the most problematic of that list.
Yeah.
How, it's almost impossible to get around, because that's why that person, he or she is helping out, is because they have something of value to offer.
Right.
And how could they be outside of, you know what I mean? It just.
Yeah.
So.
Yeah. Let's talk about the guy who does cleanup and janitorial work, that sort of thing. So he comes around, and for him, is he one that performs work that's in the normal course and scope of the church? Well, this is kind of interesting, and case law is going to define this in the future. What does it really mean? Do you normally, city code's going to require you to mow your lawn. They're going to say you need to maintain your, trim and do all that sort of stuff. So it's something that the church is regularly going to need to do, but it's not their purpose, it's not their function. So I could make an argument that under B, that a gardener would satisfy this. Someone who's just cleaning up, maybe doing janitorial. Oh, but then Jesus washed feet. Hey, next sermon, pastors, forget the washing feet stuff.
Get rid of that, yeah.
I
did it
keep
myself.
that out of it. That's not part of the message anymore.
Nope.
Okay, so free from control and direction of the hiring entity. Well, if your gardener comes when they want, you say, hey, just show up once a week, clean up, do the normal stuff, probably okay. Work that's outside the normal scope, maybe. Work that is customarily engaged in an independently established trade or business of the same. So, now this individual, if he does this for many people, he has his own company and he does that, great. This is where a lot of people get messed up also. Well, some people, they're just volunteering for you. And they're doing this, but you're paying them because you don't want to be volunteers, so you want to pay them. And they don't have their own independent business doing this. So they don't have their own independent business, you failed this. So that's where, when you talk about the code basically, or the case law was looking at it saying, a good example would be a plumber. You hire a plumber to come fix something at your house or your business. You got a business and you're functioning, it's your church. And you hire a plumber to come unclog the toilet, to fix the sink, to do something like that, that's going to satisfy all of these, particularly when the plumber is independently hired and called on just to do this one thing for that. But if it's the janitor, that's your fix-it guy that just comes and he doesn't work anywhere else, he only works at your church, well, now you failed it. Okay, let's talk about the ministerial exception. Next thing. The ministerial exception is the next big deal in employment law right now. So for churches, you have this exemption that says that bottom line is you have the ability to be able to hire who you want to hire if they are a minister. Now, the question is, who's a minister? And there's cases that say different things. So Hosanna Tabor was a case from the U.S. Supreme Court, 2012, big case. That basically interpreted the First Amendment, and it implemented case law that's been established in a lot of the lower courts over time. The First Amendment requires a ministerial exception that allows employers to discriminate against ministers without any court review. In other words, you want to fire the pastor as a church? You can do that. Court has to stay out of it. It's the so-called separation of church and state, right? They want to use it for all sorts of other reasons. Well, here, they need to stay out of employment decisions of the church. But they really don't, to be frank. The Freedom from Religion Foundation and those folks, they want to interfere with the church. They want to be involved in your church. They want to be able to tell you that a transgender individual who wants to be the church secretary has the right to employment without discrimination. So the church secretary, now what? What the church secretary is? The church secretary a minister? Raise your hand if you think the church secretary is a minister. Raise your hand if you think the church secretary is not a minister. Raise your hand if you think that you live your Christianity out all day, all the time, 24 hours a day. Okay. So that's our perspective. Is look, we want to set you up the best you can so that, hey, we live our faith out 24 hours a day. And there's been cases that have come along and interpreted these different things. I don't have a whole lot of time, but Red Hill Evangelical. So this is a case that basically is that a preschool teacher is a minister at the Christian preschool. They're a minister. They're a teacher. Are they educated? Or do they have special training? Do they do everything? Sometimes no. We had a case for a client out in Ventura where we had a preschool teacher, no training. It was a situation where the teachers were expected, however, to pray with the kids, to worship with the kids, and to teach the Word of God to the kids. all the way down to 2-year-olds, and 3-year-olds, and 4-year-olds. Are they ministers? Yeah. We went in front of the judge and said, look, the Bible talks about the least of these, about Jesus said, bring the little children to me. We believe this is an important aspect. But what really was the clincher was this. It was that the individuals were called by the Lord to this position, to this job. The church didn't just say, okay, we'll hire anybody off the street. You had to be called into this position. So I'm going to run down to this ministerial exception, and you know what? I'm going to go this way because I want you to see job descriptions real quick, and then I'll go back to a couple things. So this is a bad example of what a job description should look like for a secretary. You're required to work a minimum of 25 hours a week. Your duties will include answering phones, collecting mail, coordinating staff, welcoming visitors, maintaining employee and department directories, giving instructions, and maintaining security by following procedures, monitoring logbook, and issuing visitor badges. Sound like a minister?
No.
No? But in reality, this is the person who's sitting in front of your church, who is the first representation of Christ for that person that might come in off the street. Here's a good example. Sorry, we're lawyers. We get paid by the word. The ministry requires you to be called by the Lord to serve in this ministry function as this church's ambassador and first point of contact. The first person visitors see when they walk in the door. Or actually, I messed that up. I did this late last night. Sorry. You are the first person visitors see when they walk in the door. Therefore, it is essential that your demeanor, attitude, and presence reflects the love of Jesus Christ. Your primary duty is to minister to all those who walk through our gates. Thus, it is essential for you to be spiritually and intellectually equipped to spread the joy of the gospel at all times. Your secondary duties will include setting a positive example of Christian love by welcoming all visitors and praying with them when possible, attending and leading weekly staff devotions, answering phones, collect mail, coordinate staff, maintain employee and department directories, give instructions, and maintain security by following procedures, monitoring logbook, and issuing visitor badges. Although we expect that this job will require you to work no more than 25 hours per week, always remember that being a disciple of Christ is 24/7 commitment. You are required to regularly attend weekly church services at an evangelical Bible teaching church, depending on how you want to define all that. Bible teaching church, in order to be adequately trained in the way of a disciple of Christ. Furthermore, you are expected to be in regular study of the scriptures and in fellowship with other Christian believers. That's the kind of job description that I want to see all of our clients have. So that when it comes back to these questions of whether or not they're really ministers, they're ministers. And you should understand that from the court's perspective, they don't often understand our life. They don't understand who we are and how we are as Christians and how we operate. They just think they're answering phones. And we're like, no. They're the first person that someone who may be in deep trouble and turmoil, they're the first person they talk to. These people may not be Christians, and we need to set that example. Let me go back to a couple cases. So in the Stephen Weiss case, this just came out 2019, both of these cases. This was a California Court of Appeal case, and here it was a Jewish synagogue, and they were teachers at this Jewish synagogue. But the teachers weren't required to be Jewish, and they weren't required to be called. They didn't discriminate. And now they're saying, but wait a minute, they're ministers. And they lost because the court said, no, you don't even have to be a member of the Jewish congregation or Jewish faith. And they're teaching Jewish principles. No, that doesn't really count as a minister. In Beale versus St. James, the Ninth Circuit recently ruled that a fifth grade teacher who sued for a disability under the Americans with Disability Act, she sued, and this sounds pretty horrible, but she filed a lawsuit because she had cancer and she needed time off for chemotherapy. Well, St. James School said, no, you're fired. And I hope a lot of us wouldn't do that, but we don't always know all the facts. Sometimes the facts come out in the case law and they aren't all as pretty or as accurate, but let's just assume that was really true. even then, an argument can be made, wait a minute, the government has to stay out of employment decisions where ministers are involved. That basically means I can terminate a minister because I don't like the color of his skin. I can terminate a minister because I don't like the color of his hair. I don't like how he lisps when he talks. I don't like the size of his shoe. You know, I mean, the church has to stay out of decisions when it relates to the church and their ministers, because if they can intervene, then they can intervene in a doctrine. The government has to stay out of that. So here, the argument was the church said, wait a minute, you know, this 5th grade teacher is a minister. She taught religious courses, but she said, I'm not called to be a minister. I don't hold myself out as a minister. I don't consider myself to be a minister, and the church doesn't hold me out to be a minister. Court said ministerial exception doesn't apply. But what if we had a similar job description like I just showed you for her and said, wait a minute, you can't just come in and teach our kids unless we know that you feel called by the Lord and we feel you are called by the Lord based upon after praying and contemplation as to whether or not this is a ministry God's put in your life to teach our children. And so we want job descriptions that really reflect these needs. So we did that. Job descriptions: affirm the employee is called by God. He or she is a ministry partner. Encourage the employee to pray at all times during his or her work. Now, of course, they got to work. But encourage the employee to evangelize, give biblical instruction. Affirmatively call the employee a minister. Use the words called, vocation, minister often. Incorporate ministerial and liturgical functions into job description, like have them teach Bible studies sometimes. Have them teach weekly devotions. Hopefully they'll be part of the church and other areas. And then handbooks are really important. I'm going to skip this because you guys might address that briefly. Handbooks are important to talk about your faith. When it comes to your church, this is critical. Statement of faith, things of this nature, so that if you ever get sued by someone because they did not get a job with you, my greatest concern is not necessarily that one of your employees quits and sues you. The greater concern is that someone's trying to get a job with you and you turn them down for a position, and it's a setup because it's a transgender person, it's someone who's from a different faith. It's that type of thing where the Freedom from Religion Foundation is coming around trying to set people up. This happens. Okay, Mike, will you come on up? I've asked Mike to come. Now, Mike is, if we could take questions after. Sorry, Rick. Or write your questions down. We don't have very many questions in that box last time I saw. But you write your questions down. It'll be beneficial for everybody. So Mike is our HR guru. He and Anna. And Mike runs an organization called Infinium HR. They do payroll services, HR services, and staffing services. And we partner with him a lot. And so I thought it would be good for him to address some of the more, just push that button, some of the more intricate details of employment issues of what we're seeing today. Changes, that is. New laws.
Okay, thanks, Bob. Okay, so you guys know I'm the only guy that's not an attorney or an accountant here, because I don't have a suit like Bob today. So, and you guys think he just put this thing on last minute. I mean, he put this thing on this nice event. This is how he does it. He calls his HR guy the day before and says, hey, can you put a presentation?
I did.
Anyway,
I did. I asked him to come yesterday.
So
I was going to do it myself, but
yeah, you did great though. So anyway, so I'm gonna probably veer off a little bit from where Bob was, because we don't specialize in churches and ministerial organizations. So I'm gonna veer off. I'm gonna treat you guys like your employers, because you really are, right? If the ministerial exception fails, you're still an employer. So we want you to do things right. We want to make sure we're doing everything legal. So we're gonna go over some of the issues in California, and we want to think about California as it's all beautiful, right? Beaches and palm trees and butterflies and roses, but it's really not, because we've got a lot of new things coming up. So you guys know that the biggest thing right now that's come up is sexual harassment mandatory training. All right, so we're going to talk about that. He's already talked about independent contractors, so I won't do that. I am going to talk about meals and breaks, as boring as that might be. And I do talk fast because I know I'm going to squeeze about 10 slides in. So if you guys all would like a copy of this, after, please, I'm gonna leave you some cards, email me, I'll get you a copy of it, and you'll be good to go, okay? Work off the clock, that was a new rule that came out this last year. Reasonable accommodation, lactation accommodation is a new rule that's come up. Parental leave and baby bonding has changed a little bit. And then we're going to talk about time, I'll talk a little bit about volunteer versus employee and independent contractor. You touched on that a little bit, but I'll step in a little bit on that too. Okay, and then we'll just conclude on that. All right, so you guys know, January 1st, 2019, new law came out, sexual harassment training for not only supervisors like it used to be, but employees as well. If you have 5 or more employees of your church, you have got to do sexual harassment training, 2 hours for any supervisors and 1 hour for employees. Okay, this must be done. It's got to be done this year, right? So you got all of 2019. How many have even done this in the last year?
Quick question.
Yeah.
Does 5 or more employees include volunteers?
No.
Can
But you could.
I challenge you a bit on that?
Yeah.
It absolutely includes independent contractors,
Yeah.
and we're recommending for churches that it will include, substantial volunteers that you might include as being staff members that are unpaid.
Of course.
Like your ministry leaders.
Yeah, ministry leaders, and one of the cases that I handled a year or so ago, it was a sexual abuse claim, horrible as it was. They came back against the church, and they said, show us all the training you did for your volunteers and your staff, and so it was very important. So I would require personally, even if it's not legally required, and that'll be a question to be determined probably in the next 10, 15 years by some case, I would recommend that you have all of your ministry leaders involved in sexual harassment training for sure.
I think we're in a Me Too generation, so it's out there, and it's an exposure for everybody. Even small businesses that down to 5 employees now, they've got that exposure. So I think it's safe for you guys to run your employees through that. We do online training. We have some online. It's not church specific. I know Bob has a great course that he does too. So if you guys need any help in that aspect, you've got all this year to do it. You're pretty safe for this year, so to figure out how you guys want to do that. But by next year, you've got to provide that within 6 months of hire. Or within 30 days if you hire somebody for a project for summer, you've got within 30 days to do that, sir.
Are school teachers considered supervisors?
Do they have a supervisor is somebody that's got 2 or more employees that work underneath them? And they're
Employees,
the manager?
not students.
No, I don't think that would be considered. That'd be a little bit more of a legal question for Bob, but I don't think so.
Yeah, I would.
Yes, I'm writing them down.
No. I was, if you're writing them down, I have no answer. But I will answer that. I will suggest, in all truth, especially teachers, they need to be trained in sexual harassment.
Absolutely.
Because the lawsuits are going to come when the teacher, I've seen them, teacher didn't prevent sexual harassment of one kid on another kid. So training's definitely important.
Yeah. And it's got to be, you can't just buy one off the internet and present it to your people. You used to be able to just give everybody a policy and that was fine, but now it's an interactive training, so it's got to be, it's got to be done by a qualified professional, somebody like an attorney or an HR person or somebody that's qualified to do that. So you guys you got to jump through some hoops for that, unfortunately, but it will be well worth it to protect yourself. Okay, I'm going to go right through independent contractors. We've already talked about that. Hiring practices, how many people do background checks before they hire someone? Ooh, look at that. Are you aware of the new laws surrounding background checks? Probably are. If you don't, in case you guys that are not aware of that, but you can't, first of all, you can't ask people about their prior criminal record, right? Even as a church, you cannot ask them about that. Really, unfortunately, we don't want to know. If they tell you, that's knowledge that you have now, but you don't want to go ahead and ask it. Now, if they're performed and you find adverse action, this is the big key that just changed. If you find adverse action and now you're going to say, well, I don't want to hire this person because they had drunk driving or they were theft or embezzlement or something like that from another church, well, you've got to go through some background and say that. You've got to go now through an interactive process with that employee or that candidate and say, gee, what really happened here? We came up with some adverse information on your background check. Tell me about it, what's going on. It might not be related to what you're hiring for. It might be related to what you're hiring for, you don't know. At that point, now you have 5 days to make a decision as to whether or not you're going to continue to hire that person or you're going to go ahead and reject them as a hire. But you've got to go through this process. If you don't go through the process and you just reject them, now that employee can file a lawsuit against you and say, hey, they didn't even talk to me about it, and now you've got an issue. So there's a process that's got to be followed. We can get you guys more detail on that, but you can.
So for a church, you're dealing with this. How does it apply to you if you're hiring a minister? Well, if you're hiring a minister, then you can go ahead and you can discriminate. If you ask that question and they're a minister, I think it's perfectly appropriate and defensible in the court of law, because the ministerial exception would be applicable. There again, if it's the church secretary, that case has not yet been decided, whether or not the church secretary can be a minister. But I will tell you this, that when I was arguing the same-sex marriage case here in California, in San Francisco, and one of the leading lawyers who clerked for Justice Ginsburg, who was on the other side, led a group called Equality California, and they were one of our opposition. So David and I were on a call, and I was talking. I said, David, look, we started getting into the ministerial exception, and I said, don't you think that churches should be able to, decide that they could require that their church secretary be a Christian? And he vehemently said, absolutely not. Now, this is a guy who clerked for Justice Ginsburg, okay? He's not some nobody. Very intelligent. And he said, absolutely not. And bottom line is that from his perspective, we might have that great job description, however, that doesn't necessarily, it's not for sure, and I'm trying to give you this caveat, it's not for sure that's going to protect you, but we want to put you in the best position to be able to hire Christians as you want to hire them. And so when it comes to these background checks, sometimes I think the recommendation is avoid a lawsuit if you can avoid it. When hiring a church secretary, do you need to know whether they had a misdemeanor, some minor violation 20 years ago when they were a kid? Maybe you don't need to know.
Yeah, that's where it's going to come down to, is that whatever is on their background report, is it related to their position? If it's not, you're going to have a real tough time rejecting that person because of that. They could come back and they can sue you. So that's another big issue that we're dealing with. So that's...
I have a quick question on the background
Yeah.
check. So you have an employee, we fingerprint everybody who comes past the doors that have access to 18-year-old and under. So if you don't do this at the onset of the hire, but you fingerprint them and it comes back with something, they don't always disclose what it is, but they do indicate there's been something. So how does that backlash on you, since we're not allowed to do that?
So weren't you doing that before you hire them? You do the background?
We read it before. They can't start working until we run the background check.
And the fingerprint?
Yeah.
But, okay,
I
so...
mean, it's all one thing.
It's all
We
one
go-
process.
We go federal across the country now. We don't just do state, so.
So you're saying, but you were saying that you did a fingerprint check after?
Ahead of time. Well,
But then you hire them before you actually get the results.
we run it back, we run the fingerprint and they can't start working until it's been cleared because it's a licensing issue because we have a preschool. So it's one of the requirements with licensing in California. So they can't actually start working until it's been cleared.
Right.
So I don't know how that's gonna, I mean, I don't know if it's gonna be a conflict down the road.
Well, it's going to be a conflict if you have adverse information on that
Exactly.
person's background check, and
Right.
now you need to either
Because the state of
reject
California
it.
requires it for,
Yeah, but now you just have to go through an interactive process,
Right.
and it's going to get,
so you can do it that way.
yeah, exactly. So there is, I can say, you guys give me your information, I'll send you more info. I didn't want to go into all the details on that today, sorry. Okay, Ann is an expert in that too back there, so she's...
So the course of actions would be what? If, you don't want to hire them because of background check showing, but it's not really directly related to whatever they argue that. What would be the course of action for the lawsuit? It's wrongful termination, There's no hiring yet.
Discrimination.
Based on discrimination, based on what? What type of discrimination? SAG?
Violating a statute because now they're a protected class of individuals.
Statutory.
Prior criminal convicted, people with prior criminal convictions, Rick Gillian, have, I'm kidding.
You won't let
He
me
missed
ask
that.
a question, buddy.
Prior convictions causes you to be in a protected class now in California, so it'd be discrimination. But Mike would tell you, I mean, how would you get around it?
How'd you get around?
Yeah, say you've got a person and you don't want to hire them. They're not a minister. Let's just assume that
Yeah.
they're not a minister, and you don't want to hire them because they quit their job, for improper reasons or had a bad reference or something like that. But they also had a conviction. What would you do?
We tell most of our small business clients, we tell them, don't run background checks anymore unless you have something really, really sensitive that you're trying to protect, money. But you guys do have something very sensitive, you have children on board and parishioners and so forth. So, yeah, you have to do that. What can you do is that you need to get advice. I would get advice from an attorney, get advice from an HR person before you make an adverse selection and you decide that we don't want this person, we're going to reject them. Let's make sure. If it can be found that that is definitely related to, this is where the strength of your case is going to be. If it's directly related to your position, what their position is in your environment at the church, then you're probably a little bit safer than anything. They can still, anybody can file a lawsuit against anybody for anything, right? So, but you're a lot safer as long as you do have some steps built. Does this have anything to do with what they're doing? If it doesn't, then let's go to step B. All right, is that sort of?
Yeah, and I would also add that this is kind of how John and I met 15 plus years ago as a builder contractor. He had a church come to him and ask. He didn't want to build the church for this particular church, and his response was, "Yeah, I'm just too busy right now. I don't have the time." As a church, someone you're going to hire, say, "You know what? We just found another candidate who is more qualified." If you can say that. If it's not a candidate who's more qualified, maybe it's a budget issue. You changed your budget. Maybe you found someone who you found that this individual did not have a good reference from somewhere else, and you just felt uncomfortable with it. So you could identify something like that, and sometimes it's difficult. A lot of times you say, "Well, don't put it in writing," because you put it in writing, it can come back to haunt you. But this is the kind of thing where it probably makes sense to send them an email that says, "Sorry, but I'm not going to hire you. We found someone who is more qualified because such and such." Normally you would just say, "Sorry, we decided to go with someone else." You don't put it in writing and off you go. But when you're in fear of potentially being sued for something like that, you may need to actually put something in writing that justifies.
Well, that is part of the
Like
law.
termination.
You have to respond in writing to that employee.
Oh.
In 5 days, you've got 5 days to respond to that employee in writing and give them a copy of their background check. So this has got to be part of the job offer. You should have a job offer. It's contingent upon background check or reference check or whatever you're doing. And then once that comes back, it's hard to just say, "Well, we decided, we've got a bad reference check."
So then by that time it's too late.
It's too
You've
late.
already offered them the job.
But you had a good point though. If you had reference check, background check, contingent upon reference check, background check, drug screening, whatever we're going to do, you can be specific to the reference check. You can be but you don't want to be untruthful about it either. So yeah, it's a tricky area. So when you do make a decision, make sure that it's that you got some backup.
That's why we need guys like Mike to follow on.
I think the Consumer Protection Act that we talked about this morning probably applicable. That they will have the right to access of what you have, what's the reason for not hiring those he should be eligible. To have the right to access.
Well, they do. Yeah, they do have that access. And that's what, we usually run background checks for our clients, so we tell them if there's something going on, we usually give them that info. So, all right, so let's move on to the next, we'll be here all day. Salary history law, so you can't ask prior salary history now. So your position pays between $14 and $16 an hour, and you cannot ask them, "Well, what did you make in your last job? Can you give me a salary history?" You can say, "Well, what range are you looking for? What pay are you expecting?" You can ask them that, but you cannot ask them specifically what their salary history was. And you also need to, oops, move back more. You need to make sure you have a range. When you put a job posting or you're offering a job to somebody, you've got to have a range already preset. So you can't be kind of willy-nilly about this anymore and decide based on what they made before, I'm going to pay them this much now. So that's kind of a new on it. Okay, so meal and rest breaks, I know you guys know. How many people know meals and rest breaks just in and out and don't ever have to worry about it? Okay, how many people use a timekeeping system? How many don't? Okay, just a couple. All right, so first of all, make sure your timekeeping, I mean, your meal breaks are big. We see tons of labor claims, nuisance claims, lawsuits with meal and break. And they'll start with meal and break. If they don't get what they want, they're going to go after all the other little issues. They're going to take and throw everything. These are attorneys, no offense, Bob. They're going to throw everything but the kitchen sink at the wall. That's what they do, right? They just want a settlement. So you got to be really careful. Make sure you got a good meal and break policy. 10-minute rest breaks for every 4 hours worked, or a significant portion thereof. So somebody comes in 3.5 hours, maybe they should have a 10-minute break. 30-minute lunch after 5 hours work, unless 6 will complete the day. If you can get it at 6, you want to get a meal break waiver at that point. Free from all duties. When they're on lunch, they are on lunch. They're not to, clean stuff, take trash out. They've got to be completely free. I really suggest if you don't have a time system, find one. There's very inexpensive ones on the internet. T-sheets, there's dozens of them. Please use them. You can have them on your phone if you need to. They're easy to use.
They're apps, right?
Yeah, we got apps all over the place. Yeah, there's tons of stuff. We have a really good one too if you need to. Talk to your employees about it all. Hey, make sure you take your lunch. I got employees that won't take their lunch. I got to remind them, please take. They love working for us. So, but take their lunch, do what they got to do, and then check your time. Even if you have a timekeeping system, check your records. It might be 1 minute, 2 minutes, 3 minutes off. They might be shorting themselves. That will come up in a labor board hearing. I guarantee. They will bring every single minute that they miss. They will bring it up, and you will have a 1-hour penalty for that period that was missed. So be careful with that. And then counsel, discipline. This is if you have somebody that's constantly battling you on this, write them up for it. Don't allow them to continue without at least acknowledging it and documenting it. That way, if you do end up in court, say, hey, I told the kid 5 times to take his lunch. He never took his lunch. We had to let him go. Now you got the backup that you at least gave him the try.
I have a real quick question about
Yes,
the preschool, about the teachers.
Mm-hmm.
Because if we have an issue anywhere, it's going to be in a classroom, because we have a two adult and minimum ratios in the classroom.
Mm-hmm.
So we have a roving break person that we've hired to provide that. That's the only way we can come up with a solution. Because teachers typically don't take breaks anyway. They just are very devoted. So we had to hire somebody to come in and do breaks all day long. So.
And that's good. That's a great way to do it, yeah. And sometimes you have a situation where you only got one person and they can't take a break because they're the only person there. And yeah, that's really tough. So they can do off-duty meal breaks. Is that what they call it? Off-duty meal break? On-duty meal breaks, excuse me, on-duty meal breaks, and that'll satisfy.
Yeah, they have to be relieved of all duty, and they have the option to leave if they want to leave. You
Right.
can't tell them to stay.
Well, in our school, our teachers are exempt.
They're just because their salary is so high, or they're just a teacher's exemption?
Well, we treat them as exempt employees. Our salary is, I believe, in line with that requirement.
Yeah, you've got teachers, there's a professional teacher's exemption, so your teachers are exempt?
No, because it's a preschool.
It's preschool, yeah, okay, so,
Okay.
that's good, okay. So anyway, just be really careful, meal break, as dumb as it sounds, it's a big issue these days. Never let anybody skip a meal, rest break, train your managers, if you have supervisors at all, to watch out for that stuff. Okay, so this is a new one, this is called work off the clock. And it used to be where, a little minute here, 2 minute there, was a de minimis, how much time do I got, okay?
We're good, 10 minutes?
Okay, I only got 42 more slides, so we're good. So de minimis work just might be, little small stuff. This was a big class action lawsuit against Starbucks, where somebody would clock out, and they would walk out, and they would lock the door, they'd set the alarm, and it would take an extra 2-3 minutes. 2-3 minutes, locking out, and then they go home. Class action lawsuits against Starbucks, and they won, right? So that was a big thing. Basically, the court has said there is no de minimis time. There is no 1 to 2 minutes. It all counts hours worked. Okay, so that's a new one. whatever it is, taking the trash out, checking emails at night, hey, could you make sure you check before you come in and make sure everybody's got their schedule tomorrow? There, you've got, if anything, you're gonna do that, then you pay them for that time. Make sure that you include, and it might even be random, hey, I know that this person's taking 5 minutes a week to check an email, check somebody's schedule, pay them at the end of the week, 5 minutes, and then call it something different, de minimis time, extra time off doing the, time doing the emails. Make sure you pay them extra for that, that's important. And then just, tell employees, there's no working off the clock, right?
Real quick on that, so if somebody's like an hourly non-exempt and they have emails come into their phone, and they're voluntarily checking, is that a problem too? Should we not have them?
I do not recommend anybody that's hourly have access to email on their phone. We don't have any, although we might exempt people have access. It's just, if they are checking, if there's any expectation. Now listen, if you don't make it mandatory and you don't have an expectation that they check emails, they can, but if they send you an email and then you respond back to it at 8 o'clock at night, they've got to prove that they did.
The same thing would apply too if you're having your teachers find their own subs. That's really supposed to be something that the director should be doing or the supervisor should be doing as an exempt employee.
Right.
Because that's another one that you can have an action on.
Mm-hmm. You gotta be careful of that stuff. Okay, moving on, reasonable accommodation. So that's kind of a new, this is sort of new one, it's 2017, 18, but the Fair Employment Housing Administration requires employers 5 or more to provide reasonable accommodation for physical or mental disability. Now, the biggest issue, it's got to be an interactive process. You are required to make reasonable accommodations, but they kind of want you to be a doctor now. If you see an employee limping all of a sudden or they're having trouble with their back, you've got to now, you kind of have an obligation to approach them and say, hey, are you okay? What's going on? Can we help you out? What can we do? But if they do come to you, oops, what did I do? If they do come to you, it's an interactive process. Okay, let's see if we can make an accommodation. You may not be able to, not everybody can, but we're gonna make a, job, maybe change your job duties, they get a little bit of time off for medical care, change your work schedule, so there is some things that you guys can do.
What does interactive process mean?
It means sitting down and talking to them, and it may mean, getting a job description. That's what job descriptions are very important, and not only on the ministerial side, but having the details of what they do, how much they lift, how much they're on their feet, all those things. You may have to get a job description to their doctor, right, to the physician, and say, could you please let us know what their limitations are. And when you do have an issue like this, you want them to go to the doctor. You want to see restrictions in writing from a physician that says, hey, you can only, they can only lift so much weight, they can only walk so much, make sure you get it detailed, have a process in writing so that you're backing yourself up. Anna's really good at all that stuff, she does that a lot. So that's important. Okay, so that's a new one that's come out. Lactation accommodation is fairly new. Before, you used to just have to have reasonable effort, provide a location. How many have moms that are working in church? Okay, so, or new moms, I should say. They used to be able to just, anything, maybe bathroom stalls, as long as you have a private area, someplace that they can go and do their pumping. But now, must be other than a bathroom, so you cannot say, hey, just go ahead and use the bathroom stall. It should be a permanent location. Small businesses, obviously, small churches are not going to be able to have a permanent location to do that, so there is going to be some gray area as far as what's reasonable, what's not reasonable. It can be temporary if it's an undue hardship, but definitely you still need a private area. You've got to consider refrigeration, right? So we got some things to think about as a business if you have new moms that are there. Take the steps to make sure that they have some place to go. So that's kind of a new law. Okay, parental leave. This is kind of a new one now. We've got baby bonding. That's 2019. It's a brand new one, right? Yeah. So 20 to 49 employees now need to provide eligible workers. There are some eligibility requirements, 1,250 hours worked, and a few more hand knows those. But you've got to give up to 12 weeks of unpaid protected leave, and that'd be baby bonding, right? And this includes mothers and fathers. It used to be just mothers. Now it's mothers and fathers. The 20 employees more, right? So dad, we got a brand new dad. He says, I need 12 weeks off to go mom with my baby. And you got 20. How many more? I have 20 more employees. Okay, so we have a couple, right? So, and again, how many employees do you go to, right? When you talk about volunteers and independents. So, and then PDL, pregnancy disability hasn't really changed. I mean, you guys know this, right? That law's been around for a while, so I won't go into too much detail on that. And then anybody with 50 employees, more? Yeah, so 50 employees now, you still got FMLA, so you still gotta make sure you guys do that whole process of setting that 12-week period up. Okay, so this is another thing I'll talk about, this is probably one of the last slides. Employees get paid for their work, right? Volunteers should have no expectation of getting paid, like Bob was saying before. It's like, well, maybe we'll kick in a little bit, Monday, Sundays, and doing the ministry, the church will kick in and we're gonna give you $34, $30, $40 or whatever. Well,
Or script cards.
what's that?
Or script cards.
Right. They are now not a volunteer anymore, right? And a lot of churches are changing this too. A lot of changes in the whole structure. But you've got to make sure there's a delineation between what your employees are doing, what your volunteers are doing. And there's also, most church workers, if you've got somebody there, they're going to fall into a paid employee category. Volunteers, truly, they're just volunteering. The issue comes up, what happens when you have an employee? You have a teacher who now wants to volunteer on Sunday. Are they an employee or are they a volunteer? What are they doing? Are they doing something completely separate? Right? It should be, right? Because now we're Sunday church, we're not in school anymore. So really what we need to do is review those. Make sure that you guys have something in writing. If somebody's going to be a volunteer, have a little volunteer form that they fill out. Yes, I agree, I'm going to volunteer. A little spot they can fill out. This is the function that I'll be doing in the church, and they write it and they sign it. And if they're an employee, that they have a really clear job description. If that ever comes up, now you've got, well, look, he was over here, he was fixing flowers for Easter morning, and over here he's a teacher.
It should be unrelated to their primary
Should be
responsibility.
unrelated, right? If they're coming in and then now, let's say on Tuesday, the teacher only comes in Tuesdays and Thursdays and wants to come in Wednesday and help one of the other teachers out. I'm just going to volunteer. I'll just spend my time in the classroom doing the same thing that they do every day. That's a problem. You don't want to do that. Thank you. So yeah, just make sure you have a really good delineation between those.
Excuse me.
Yes, ma'am.
So if a person is working 20 hours a week at a specific job and then does the other 20 hours doing that same job, is that?
If one is a volunteer and one is an employee?
Yes.
That's a no-no. I would not do that. Yeah, that's exactly the situation that I'm describing, yeah. Yeah, because like what's the difference? Why would you not pay them? See, the way that the court looks at things, and Bob says, they think everybody's a bad guy, right? That you have a motive that says, well, I don't want to pay them overtime because they might work 45 hours that week.
At least the labor commissioner.
And the labor commissioner, yeah. So they're looking at things.
Well, if it's a small business and, they're trying to save some costs perhaps on health insurance and whatever the case may be. I'm just asking.
And see, that's what the court doesn't want you to do. They don't want you to make exceptions for employees just to keep you below below the health benefit rule or below anything else. They're saying if they're an employee, they're an employee. So you don't want to mix those two. That's really important, okay? Court, hey, we're all bad guys to the labor commissioner, right? Okay. Might have been, last one. So, really bottom line, we'll open up for questions, I guess, but being an employer, a church employer, anything is really difficult. We're in California. California is the toughest state to do business in, maybe besides New York. And we're seeing a lot more labor claims now. So you've got to make it a deliberate process that, realize that you guys are a church, you guys do wonderful things, and we're also a California employer. So we've got to take some steps. If we don't have a plan, we don't have employee handbooks, we don't have a hiring practice that puts everything in writing to back ourselves up, then you're going to get into some trouble. You have a plan, get some help, have somebody you can call, attorney, HR, somebody that you can call, hey, you're thinking about this, because listen, what sounds good to you and I don't think I have it. Yeah, what makes sense to us doesn't make sense to California. And what you think and what the employee wants to do, if the employee says, well, I'm not going to work overtime this week, I don't want the overtime, just pay me regular, just to be a volunteer. You can have any agreement you want with that employee, but guess what? The courts say no. They can't waive their rights they can't waive their employment rights. So make sure. Just being kind of, we're churches, we're Christians, we want to make sure we treat our employees right all the way around. And then I say get the big issues right: vacation, sick time, meals and breaks, all those really basic wage and hour functions. get them right, and you should be okay. So that's it.
Can I, one thing I would just add before we take our first question is, does our insurance guy here, Don McClure, will insurance cover wage and hour claims?
Yes, EPLI.
EPLI. Gotta buy EPLI,
So you gotta
which is
review
not
it.
just your general liability, it's an additional policy.
Yes, endorsement.
What's the limit? What's the
It
dollar
depends.
coverage?
It's
Coverage.
1 million, 3 million, I mean, it just depends on the limits that you choose, but usually it's 1 million, 3 million that covers, or whatever your EPLI is. You asked EPL, employment liability practices? Did you ask what
I
that
don't,
was?
No, I mean,
Employee practices liability?
yeah.
Yeah. I thought, I heard you ask what it meant, so I was just,
so usually a deductible.
Just to her, yes, I did.
Yeah.
Usually there's-
Yeah.
Usually there's a deductible of some kind.
oh, yeah, there is retention on that, yeah, but I thought you meant that, yeah, it's like 2,500 or, 5,000, it just depends what policy, yeah.
Well, the average claims though are unbelievable that you get. If you,
A lot of,
I mean, you can just go to arbitration, you're talking $60,000 before you even get there,
That's just
And
for the
lawyers know
just for the
that.
lawyer.
Lawyer, you know, I went to a labor board hearing in San Bernardino one day, ran into a lawyer, settled
Mhm.
$5,000, he's happy, he walks away with $1,500 or
Yeah.
whatever. I see him the next day in Long Beach for another client at another labor board hearing,
Yeah.
same guy. Looking for $5,000, $10,000, $15,000 settlement, so they'll nickel and dime you to death, and they're happy and they'll get it too.
Mhm.
Unless you guys have all the backup and all the documentation.
I have one other thing I'd like to add. I worked with the church doing a construction project, and I insisted on doing a project with a licensed and bonded contractor, and they said, no, we have our own guy. And it was a general contractor that went to the church, and I'm like, okay, we just make sure that he's got liability insurance, workers' comp insurance, all the things that he needs to have for the subs that come in. Okay, no problem. Well, fast forward 18 months of construction later, and we get an invoice from the insurance company for retroactive workers' comp for all the subcontractors that general contractor did not have covered under his workers' comp. $125,000 invoice to the church for that guy's subcontractor's workers' comp, just workers' comp. Now, you make a stink about that, and now it gets elevated to EDD, and now you're paying payroll, taxes, penalties, all of those things, because you didn't include those people under the insurance that they needed, therefore they should have been your employee. So there's a whole nother spin to this independent contractor thing that's not apparent at the level, at the
Two
surface.
things they need builder's risk.
builder's
You have
risk
it as
is
an additional insured. Anytime you ever do work on any property, always be an additional insured. Always add that to the policy, who's ever working on your property, and they need to show you a certificate of insurance as well. And then, what's the second thing?
builder's risk.
Builder's risk. Always have a builder's risk policy. Covers those kind of things.
In regards to job description, would it help the churches if they referred to scriptural references for the positions? For example,
Absolutely.
administration is a gift of this church.
Yep.
Hospitality is a gift.
Yep.
The ministry of helps for janitorial.
Yep.
If you put that in there, and then when they have an issue come up, then they say you have to meet these qualifications. And if they do a background check and there's a problem, then can you use the scriptural references as a potential reason for not hiring them also, because they didn't qualify scripturally, because they
Yes.
have to do certain things. So that would help.
Yep, scriptural references are great.
Can you clarify the minimum salary for an exempt employee?
40,
It's 2 times the minimum wage, so whatever the minimum wage is at the moment, changes it.
yeah, it's like 46. Depends on if your church is over 25 employees or
Less than.
not. Less than, okay, so you're $11 times 2,080. $12, I'm sorry, I can fix that. Staffing company got employees left and right, where's my
We'll answer that question, he'll calculate that out. Next question?
We're in Orange County.
So if you have volunteers that are coming in, maybe just for construction, what kind of insurance would you want there? Because do you have to have workers' comp on a volunteer, or what do you do?
workers' comp is a completely separate thing.
the-
So as a volunteer, that's gonna go in your general liability policy, and you should just make clear before you start anything that you talk to your broker or your agent, I mean, whoever you have, and make sure that that's, volunteers are well covered under there, because it kind of changes per carrier. And then find out, you know, if you're gonna do any kind of construction, that that volunteer knows what they're doing. Because if they don't know what they're doing, they can come back and, you know, come after you. And make sure, I mean, just get a certificate of insurance. I mean, it's volunteers, it's churches, I get it, I grew up in them. And so it's tough financially sometimes, but it's too risky to, you know, you shouldn't have people climbing ladders that are volunteers that don't know what they're doing. You know what I mean? It's just, there's too many falls and risk, keeps him busy.
I had a guy, a case of a local church here in this area, sued for, had a multi-million-dollar lawsuit because he was working late at night as a volunteer running electrical wire. And purportedly had the experience, fell off of the top of a wall, hit his head, and the claim was that the church was negligent for not having someone else there to help him, and that the construction wasn't, the wall that was previously built was not up to code. And so the general liability policy kicked in, and frankly, the policy was only $1 million. And it wasn't enough to cover his damages. He had some permanent brain injuries and permanently disabled at about 50+ years old, and it was tough.
This giving people this title of minister, and wherever you stick them, it's the minister, the secretary, the minister, whatever. Is there a point though where they're gonna come back and say, come on, you just give everybody the name minister just to get.
Yeah, potentially.
Right?
Yeah, and
At some
but
point they're gonna.
that's why you've got to be very careful about, you know, in truth, praying about it. Your secretary, you don't need to call your secretary the minister of secretarial support, but, and I don't think you necessarily you don't have to include minister in their title.
Sure.
Reverend Secretary Smith.
Yeah.
You can say, I think what you do is it's in the job description. It's a matter in your employment, in your staff meetings. You are all ministers of the gospel. You are here because you are called. If you were not called, we would not have you here in this position. And as soon as you feel you're not called, it's time for you to move on. We want God's purpose in your life. You know, that kind of thing consistently as the leader of the fellowship that you have.